Hello, my name's Osha. I like talking about American presidents, and today I want to talk about the a case concerning our 27th president, William Howard Taft, when he was Chief Justice of the U.S. Supreme Court. Of course, Chief Justice Taft is the only American president who was head of not just the executive branch as president, but he was also subsequently head of the judiciary as Chief Justice of the U.S. Um, so I did an earlier video discussing one of his infamous cases, which he decided it was a civil rights case. It had to do with segregation, and he basically expanded the scope of segregation, to include Asian Americans as colored people, and that segregation was constitutionally protecting whites, right, against colored people. In this case, the case was Lum versus Rice, and of course that was subsequently overturned in 1954 with the Brown versus Board of Education case, which said segregation in public schools violated the equal protection of the law and was unconstitutional, and basically overturning the Plessy versus Ferguson, which it said separate was equal. Because parallel systems had been created due to these segregation rules, and of course, what it ended up doing was it was also very costly. So the other thing about the unconstitutional ruling regarding uh, uh, Lum versus Rice and Plessy versus Ferguson through Brown versus Board is that the political climate also favored that constitutional ruling. So, the Supreme Court is pretty much a also a political vehicle. We find that they're not insensitive to the political climate. That's the Supreme Court. They're not insensitive to the political climate. It should be an independent judiciary, and they should try, and they're supposed to be following the rule of law in a scientific manner, of course, which, but we find that there's this back and forth. Law again is also not scientific. It's very subjective, and we find that in this other case of Chief Justice Taft, it was another poor ruling that was subsequently overruled, decades later. So today I want to discuss. It's a criminal law case which was decided by the Taft Supreme Court. It's called Olmstead versus the United States. It was subsequently overturned with another case, Katz versus United States in 1967. And so this has to do with Fourth Amendment, and it also implicates Fifth Amendment. So I'm interested in this because I loved criminal law in law school. So Fourth Amendment has to do with unreasonable searches and seizures. It says that you know the government shall not, conduct unreasonable searches and seizures um, in someone's home, right, uh, without a warrant, you know, issued without a warrant which is predicated on probable cause issued by a neutral judge, right, an impartial judge. So uh, the case of the Olmstead case, it's about a guy called Roy Olmstead. Roy Olmstead he was wiretapped, so the evidence was against him uh, was procured through wiretapping, right? And he was based on this evidence that was gotten acquired through wiretapping. He was convicted of bootlegging, so he was convicted of a violation of a National Prohibition Act. So this was the era of bootlegging. The case was 1928, and of course, there was the 18th Amendment, which made the production, sale, and transportation of alcohol illegal. So apparently, so he was that's Roy Olmstead. He was convicted, and so he filed a suit, an appeal through the Ninth Court of Appeals, which confirmed, and then it subsequently it went all the way to the Supreme Court, and of course it came to the desk of Chief Justice William Howard Taft. Um, William Howard Taft made some very interesting rulings, of course, which are uncanonical today, right? So again, you see the law is very subjective, and you see, in fact, maybe with the power of hindsight, but as I read his opinion, it didn't, it just didn't, it wasn't one of the more clever opinions that have come from the U.S. Supreme Court. So Pre- Chief Justice Howard Taft, of course, who was also President Howard Taft, who had been President Howard Taft, he decided that uh, the wiretapping of Olmstead to secure the evidence was not a violation of the Fourth Amendment. So let me give a little more backstory. Um, so Olmstead had been operating this uh, bootlegging operation enterprise, and so the way the government obtained the evidence against him was, placing, bugs, hearing device, uh, listening and recording devices around his, in public areas around his office, close to his office, and things like that. They didn't have to go into his office or break into his own home, which was which was consequential in the decision of Chief Justice Taft's court. So they didn't have to break into any of his properties, into his offices or anything like that. The listening devices and recording devices were in the public space, or on the streets, right? So that's where they were listening in on the conversation, and the conversation ended up exposing the personnel, the operations of the bootlegging activities, and he was consequently convicted. Now, Olmstead was claiming as a petitioner that violated his Fourth Amendment rights, and his Fourth Amendment rights, which protect him uh, from a warrantless search, right? Because protected him from unreasonable search and seizure without a warrant uh, in his home. It's supposed to provide him a reasonable expectation of privacy in his home regarding his papers, his belongings, personal effects. They cannot be seized nor searched without a warrant, and no warrant was provided. Now, Chief Justice Taft wrote the opinion, and he argued that one, um, there was no trespassing, right? He seemed to have this reading of the law, right, of the Fourth Amendment, that it protected one in their homes. That's in order for there to be a violation, the police or the government has to intrude in physically on in the property of the petitioner. And Chief Justice Taft was of the opinion that there was no physical invasion of, the property of Olmstead. There was no seizing of his papers. There was no seizing of his person, and so that a warrant was not required. And there was no violation. That's how he saw it. So he seemed to believe that a physical intrusion was required for there to be a Fourth Amendment violation. And he said, because of the technology of the telephone, right? The telephone was not the hearing devices, consisted of wires, and that the telephone itself operates is a form of technology that you know uh, that that conducts conversations over long distances, to remote areas, and the wires that are required are not physically located in the petitioner's home. They're not, that the cable, the system of the telephone is not located in the home of the petitioner who's saying that there's been a Fourth Amendment violation, right? There's been an unreasonable search. So he, Chief Justice Taft was saying that in fact Congress has to create legislation first, right, to for it to address the issue of the technology of telephones, and he felt that the Fourth Amendment did not apply to telephones. Now he used as an example, uh, as an analogy, a case which was decided in 1914. It's Weeks versus United States, which prohibited uh, illegally obtained evidence. Right, this was a case where it had to do with racketeering, gambling, right, and lottery, where the government opened the mail, right, opened the mail and letters of the petitioner, and so of the defendants, and so uh, Chief Justice Taft was saying that in this case that there are two different instances, right? That mail that the Fourth Amendment protection, which prohibited, which made evidence illegally obtained inadmissible, that it had to do with mail, right? That the invasion of privacy had to do with, that this was a instance of mail and physical access. And he said, that hearing devices, telephone conversation was not similar. That those protections that that cover the invasion or the opening of mail did not were not parallel to the conversations over the telephone. So it was poorly reasoned, right? He was, he seemed to assume that there had to be some kind of physical invasion, right, of the property of the petitioner. They had to, and then so he didn't see how uh, there was a reasonable expectation of privacy in a telephone conversation, which he said was conducted voluntarily. That it was that the hearing devices were placed in a place were placed in an environment where people went to voluntarily. I think that actually, so that's what occurred later on in Katz. I'm going to do a subsequent video and just explain Fourth Amendment generally. So in Katz, which overturned, Katz eventually overturned the ruling of the court as opined by Chief Justice Howard Taft in Olmstead versus United States. So in Katz, the government was saying that the court decided that and I think it was Chief Justice Harlan. Uh, he decided that, or Justice Harlan, anyway, they decided that there's a reasonable expectation of privacy in a phone conversation in a booth, right? And so that subsequently overturned the poor decision in Olmstead versus United States. And in fact, the case Olmstead was eventually vacated. The conviction was subsequently vacated. But as of that time, because Chief Justice Howard Taft said there was no violation of the Fourth Amendment, that no, he focused more on a physical violation, that there was no trespassing, right? That he seemed uh, to presuppose that there had to be some kind of trespassing for there to be an intrusion and Fourth Amendment violation. So he wasn't really expansive. He wasn't really focusing on the reasonable expectation of privacy, um, as one would expect in electronic using electronic devices. So And that is what eventually came out in the Katz ruling in 1967, which overturned Olmstead. It focused on the reasonable expectation of privacy when someone's using electronic devices, using the telephone, and things like that. So um, yeah, so it's kind of interesting the way Chief Justice Taft ruled. Where he was saying, one, that there was no trespass, and there was no physical intrusion, um, and that sort of conversation on that the wires, that the devices mechanism for telephone does not reside, is not situated in the home of the petitioner, and therefore he can't have a reasonable expectation of privacy. Right? There's no way that the government can intrude or provide protections just because the technology, the wires and things like that, for that allows the telephone to operate, do not are not located in the home, in the premises or the property of the petitioner. You know, I'm gonna do another video just discussing at length the mechanics of the Fourth Amendment, including exclusionary rule. So later on, in around 1939, this was after the decision, something came up called the exclusion. Sorry, the fruit of the poisonous tree. So exclusionary rule has to do with the sort of evidence that's admissible. So it's saying that evidence illegally obtained by the police cannot be used in the trial at court to convict the defendant. And so that's the exclusionary rule. And it just basically saying that certain um, uh, illegally obtained evidence by the police cannot be used. And this came up subsequently, like in 1920, in a Silverthorne company, the case called Silverthorne Company versus United States. And by 1939, there was that fruit of the poisonous tree, which was a metaphor which was used by Chief Justice, not Chief, sorry, Justice Frankfurter, fruit of the poisonous tree. So the poisonous tree is the illegal means of obtaining the evidence. Used the police used some kind of illegal activity to obtain evidence without a warrant, and the fruit is the evidence that came about, that was obtained through the illegal means that the police used, and it can't be used in a court. It's saying that the tree is poisoned, right? It's a poisonous tree, so that the fruit itself is tainted, and so uh, and it's got to be a direct connection. This came up later on. That's a 1939 metaphor. It was in a 1939 case, and Justice Frankfurter used that metaphor then. So it still applies, regarding, he basically defined it properly. That's fruit of the poisonous tree. Um, Now, there was a dissent in the 1928 case uh, 19, in 1928 case of Olmstead versus uh, United States. Of course, Roy Olmstead was convicted. He spent some years in jail. He was convicted. I think he was sentenced to about 4 years, at least 4 years. But he got a presidential pardon from FDR, Franklin D. Roosevelt, in 1935, and he became a Christian Science practitioner, and he started doing work with the jails, and he started trying to, because this had to do with bootlegging, and so he was a reformed man. And subsequently, with 19 you know in 1967, um, when Katz versus United States overruled Olmstead versus United States, saying basically that that was bad law, that it was a bad ruling, his conviction was vacated, but he'd already done his time in jail. So that's the way our laws have been going. Our laws are not, we use English common law, and our laws are not. It's not like we already had the architecture and the system built ahead of time. It's just the same thing with even our nation, right? Um, when Jeremy Bentham was uh, was writing a rebuttal in his short review of the Declaration, and our founding fathers, Thomas Jefferson, had said, well, they no longer wanted the British form of government. Jeremy Bentham had, of course, maybe tongue in cheek, but he'd raised the issue that, okay, that they haven't stated what sort of government they're going to be replacing the British rule, the rule under the king, with, which is true, right? We didn't already have a constitution available. We didn't have a structure, a system of government available. It was this. These came up later on in the Continental Congress, and we had the article. The provisional the provisional government came up with the Article of Confederation, which gave us a very weak central government, and the states were sort of stronger. And until we changed that in 1787. So the same thing with the courts. Sometimes it looks like we're winging it. Our judges are winging things, and so it's not like we have things. We don't have our rules already preconceived. There are certain principles that we have, and we try and um, make decisions. Our judges try to make decisions uh, with the principles, underlying principles, sort of as a template that they can use for guidance. And there are ebbs and flows. Like a pendulum. One time it's this way, like it goes the way Chief Justice um, Howard Taft viewed the Fourth Amendment, saying, well, in Olmstead, that uh, a warrant, a warrantless wiretapping, was not a violation of the Fourth Amendment, and because there's no physical intrusion. And decades later, another court said that no, uh, that is actually a Fourth Amendment violation because it violates the reasonable expectation of privacy that a, an individual still has a reasonable expectation of privacy even when there is no physical intrusion in their home or in their on their property. That using listening devices or hacking your computer, right? If the government is surveilling your computer, without a warrant, right? It's violating your reasonable expectation of privacy. In the case of Katz versus United States, the government was saying, which overturned the Olmstead decision, the government was saying that there's a reasonable expectation of privacy when an individual is using a phone booth to have a conversation. He doesn't expect people to be listening in on his conversation. So, it violates the unreasonable search and seizure without a warrant rule. That's the Fourth Amendment. Now, interestingly, in law school, they taught us to pay attention to the dissent. So Chief Justice Brandeis wrote an interesting dissent, and it's funny. I belonged in the Brandeis Inn when I was in law school. So we had these inns in law school, and I was in the Brandeis Inn. So Chief Justice, sorry, not he was not Chief Justice, it was Justice Brandeis. Um, he dissented with the majority opinion that because there was no physical intrusion, that there was no violation of the Fourth Amendment. Uh, Justice Brandeis focused on the illegal way the government obtained the evidence to convict Roy Olmstead through a wiretapping that did not um, have a warrant to back it. So Justice Brandeis importantly said that the government cannot be a lawbreaker because it will create anarchy if the government is a lawbreaker. The government cannot say because they're trying to get a private criminal that the end justifies the means. Of course, what does end that phrase "end justifies the means"? Of course, that's Machiavellian. That's Niccolo Machiavelli. You know that you will do anything just to secure an end, including using unscrupulous means. And Justice Brandeis was saying that um, in order to keep the law, the government should not be a lawbreaker. And uh, with the unscrupulous a notion that the end justifies the means, that it will create anarchy, right? That it will create anarchy, and Justice Brandeis said it was pernicious, right? Pernicious means it's dangerous, that it was pernicious for the government to resort to such means, and it would eventually trigger retribution. If the government is a lawbreaker, it would cause citizens themselves to be lawbreakers. It would trigger retribution, and they would become a law unto themselves. So these were the ethical arguments that Justice Brandeis raised. If the government is a lawbreaker, then citizens would have reason to be lawbreakers themselves, and they would seek retribution, and they would be law. They'd be a law unto themselves, because the government is being unscrupulous, and it will create anarchy. So I'm going to do another video just to talk about the Fourth Amendment in more detail. It's interesting. We should, to look at a number of the cases by Chief Justice Taft. It's funny. When I was in law school, we never once touched on his cases uh, because he was really on the conservative side. He did a lot of uh, cases also regarding commercial activities. And of course, he was on the conservative side. He was on the side of the corporations, the trusts. So, his buddy who worked him into office, uh, his predecessor, that's number 26, Teddy Roosevelt, was known as a trust buster. So, trust was the term used for multi corporations, big corporations. So they were creating trusts, right? And so he was known as a trust buster because they were so big. These corporations were so big, they had monopoly power. They colluded, and so the idea of the antitrust law, starting with the Sherman antitrust law, which was actually originally passed under Benjamin Harrison, was that to limit collusion, anti-competitive behavior, right? Because these big trusts could not engage in price fixing. They had monopoly power, and they limited competition. And of course, they could raise prices arbitrarily, like when companies could now collude together, big corporations, and raise prices uh, arbitrarily, which made the common man suffer, the ordinary American suffer. And so that was the idea of being a trust buster. And Justice Taft, in fact, when he was President Taft, he sort of initially he went against some of these trusts, the big corporations, but Teddy Roosevelt accused him of siding with the corporations, that he wasn't, was basically paying a lip service to trust busting. When he was Chief Justice, he was really he made decisions that favored corporations. I'm going to do another video just talking about some of his cases, and I want to talk more about the Fourth and Fifth Amendment. The Fifth Amendment has to do with due process, right? Due process of law. And this case, the Olmstead case, was very important because so the Weeks versus the United States, it was saying that the federal government could not use evidence that was illegally obtained. It was applying to the federal government. And then in another case called MAP versus Ohio, it now applied it to the states. It brought it to the states. And subsequently, the Olmstead case, which Chief Justice Taft was saying, well, because there was no physical intrusion by the government, that the warrantless wiretapping did not violate Fourth Amendment. By the time in the Katz case, Katz versus United States in 1967, which ended up overthrowing the ended up overthrowing, ended up overruling. I guess they mean the same thing. Ended up overruling the Olmstead case as decided by Chief Justice Taft's court. That was saying that uh, warrantless wiretapping, especially for instance of somebody in a phone booth, violated the reasonable expectation of privacy and constituted um, an illegal search and seizure. It's funny. One of the things that Chief Justice Taft was saying, in his opinion, was that no search occurred. There was no seizure, right? There was no search. There was no seizure. And it's kind of funny because he seemed to have been keeping to one. He didn't view the word search. English. I'd done something on language. It's also it has polysemous terms, right? Polysemous means a word having many meanings, right? Or you could say ambiguous, polysemous, polysemantic, right? It's a word that has many meanings. So search has many meanings. There's no evidence that the court meant just one meaning. Search can mean you're ferreting through something, right? You're actually rifling through, you're ferreting through something. That's a search. Search can also mean just an examination, right, or an investigation to find evidence, right? Search can also mean probe. It can mean, so if you're just examining to find evidence, you don't have to rifle through things physically. So, Justice, Chief Justice Howard Taft clearly he was not focusing on the polysemantic or the polysemous nature of the term search, right? He seemed to have limited it to that searching meant they had to physically rifle through materials, right? And not, well, that the act of listening, probing, you're probing, you're investigating because you're examining, because you're listening. There's a search. You're listening, investigating to find evidence. You're listening, you're probing. You don't have to rifle through something, right? And yeah, our justices, they're not perfect. They're not mathematicians. They don't. They are subjective and they have a bias. And if they have a bias, they may tend to follow that bias and look for the evidence they need or the arguments they need to buttress that bias. And we see that's what Chief Justice Howard Taft was doing, because search obviously is a polysemous term. It's a polysemous word, and so you don't have to rifle through or ferret through something for it to constitute a search, which is what Justice Taft was saying. He was saying, well, that no search occurred. Meanwhile, there was a search. If you consider search as a word that means investigate, because they were investigating by listening, probing, or examining. When you're listening, you're examining. You don't have to. When you listen, you're examining information. Investigate, probe, or you're examining to find evidence, right? To find evidence of a crime. That's actually one of the definitions of the term search. You know. In any event, I'm going to stop this video here because I'm going to do something else, just discussing the Fourth Amendment. This is an opportunity to discuss the Fourth Amendment. I enjoy doing Fourth Amendment in law school. I had a case that we had to really go over the Fourth Amendment with a fine tooth comb. What's that expression? We had to really examine, interrogate the Fourth Amendment, read a number of cases. And one major Fourth Amendment specialist, of course, he came later on, Scalia, Anthony Scalia. He did a lot of work on Fourth Amendment. And I promised to do something on Fifth Amendment as well, because the Fifth Amendment was also implicated. That's due process of law. So you see Fourth Amendment and Fifth Amendment, they often go together, right? Following due process of law. My name is Olurotimi Osha. I like talking about American presidents, and I also draw attention to color of law violations, pivoting on subordination of perjury and fraud on the courts. Of course, the court in Montgomery County violated my Fourth Amendment, my 14th Amendment, my Fifth Amendment rights, and they violated my Sixth Amendment rights. In fact, there was an abusive process and outright fraud on the courts. the state attorney's office filed a prosecutorial bad faith, malicious um, charges, against me after the Montgomery County Police fabricated evidence, used got evidence, through illegal means without an arrest warrant. They didn't give me notice, and they coerced, suborned an illegal emergency evaluation petition by a man who fabricated uh, his evidence, Jide Iwariri, who impersonated himself as my uncle when he's not. My family is alive. My family is taking Jide Iwariri to court regarding this in Nigeria, that he's not my uncle, and everything he wrote in his emergency evaluation petition was false and malicious. I'm seeking justice. I'm hoping I expect to be vindicated. There's been a corrupt judge who also falsified evidence, Judge James Bonifant of Montgomery County, Maryland. So it's kind of interesting that I'm focusing on the Fourth Amendment case by William Howard Taft, Chief Justice William Howard Taft, our 27th president. That's the Olmstead versus United States case of 1928, which was overruled in 1968 with Katz versus the United States. I'll keep you posted. Thank you.